So did you see that in your syllabus, there is one topic on precedent? Think that word? I guess some unit 4th or something.
I don't know, ma'am. Just a second.
Wait, I have the syllabus. I'll open it. Okay, so this one, unit, your module 3. Okay, identifying law in judgments. So what is a judgment?
Which is passed by any court.
Yeah.
Or any.
Yeah. Passed by a court. It might be a body which is similar to a court, like a tribunal, commission, like that also. So identifying law in judgment, that means in a judgment also there can be a law. Okay, otherwise what we see in a judgment, it's like court would try to provide justice to a parties, right? Court may impose some punishment, some penalty, compensation. That is the common understanding. But then in a judgment also there can be a law hidden there. So what can be a law which is there in a judgment? Anything that you can think of?
No, I don't know. I think the judgment passed by the judges can be law.
But then what judges are saying? Judges are simply saying there is already a legislation. This is the punishment given. So based on that, we are giving this punishment to the accused person or to the convicted person. That is what they are saying. But then what is law in a judgment? Because judges are also ultimately referring to the law, right? The legislation, the statutes which we have. But then what is law in judgment?
Yeah, I don't know.
We discussed this, right? Common law countries and civil law
Yes,
countries. So what judges will do there in common law countries?
I think they they pass their judgment.
They do pass the judgment, but there sometimes what happens, right? Even though we have a written legislation, or like in India, if you take the example, we have thousands of legislations talking about different areas, but still there may be one area where we still don't have a law, or might be there is an area where even though we have a law, it's not properly addressing the issue. There what courts can do is, while giving a judgment, right, while deciding on a certain case, court may say that on this certain issue we still don't have like a proper law, and that's why we are giving this guidelines, we are passing these guidelines which will be binding just like a law passed by legislature. All right, that means in a judgment courts can provide list of guidelines which need to be followed, and those guidelines would work just as equivalent to as like a law, regular law that we have. Okay, like if you talk about such laws, there is one famous case, DK Basu case, where list of guidelines were provided, list of rights were being given to prisoners, and those are followed even now. There was one case again, Hussein Nara Khatun, where also few things were said. There was a judgment wherein court said that witness protection scheme, court basically validated it, and court said unless and until we have like a specific law, this witness protection scheme will be applicable, and that's even applicable now. That means those are nothing but law in a judgment. While deciding on a certain case, court mentioned something which became like a law, which became applicable just like a law. Okay, so today we are going to study judicial precedent as a source of law, because if you see this module 3 from your syllabus, there it also talks about precedent. Now, what is precedent? Judgment you already understood. While deciding on a certain case, what court says, that's nothing but judgment. But then what is precedent? Have you heard this word before?
I think it's similar to preceding one, like this.
Preceding one. Okay. So precedent basically means that whatever judicial decisions are given, right, whatever judgments come, it's not like this judgment is valid only for that given case. only in order to provide justice in that case, we would refer that judgment. After that, it's of no use. It's not like that. Judgment will be valid even afterwards. How is it valid? Because take for example, if you decide to start your practice after completing LLB, when you are going before court representing a client, and you are saying that my client should be getting this, should be getting that, you cannot simply make a statement. Your statement should be supported by some judgments also. There it becomes relevant. Okay, you will look at previous decisions where court has given a judgment in favor of that certain person. You will refer those judgments and you will appear before court. That means to give strength to your arguments, you will use those judgments. Similarly, courts will also try to take help of previously decided judgments. Okay, so that concept is called as precedent. That means previously decided cases or judgments or decisions are binding on whatever decisions are to come. And that concept is nothing but precedent. Now we'll understand it clearly. In simple words, judicial precedent refers to previously decided judgments. All right, it is previously decided judgments. It might be a case which was decided in 1950, 1940, 1980, whatever it is. That can be considered as precedent. That means it is previously decided judgment. But of which court? Is it like any random court? Is it like a city civil court? Is it like a municipal court? Which court is it? It is of superior courts. That means of High Court and Supreme Court that we are referring to. Okay. Previously decided judgments of superior courts like Supreme Court and High Court, which judges are bound to follow. That means whatever higher courts have already decided, it's like a set law, it would apply. Once they have used their brain, decided on the matter, taking a lot of their time and effort, same task you don't need to repeat in every single case, because similar cases are going to come before court. Every single case, every single time, you need not waste your time. If something is already decided and there is no problem in that decision, you can simply follow it to give decisions in the subsequent cases. If there is a problem, definitely you can make changes there. No problem. But when something is already decided, let's take that as a set law and just try to follow it. And that concept is nothing but precedent, that we follow whatever is already decided by the higher courts. And this binding character of previously decided cases is important considering hierarchy of courts established by legal system of a particular country. And India also, we have a certain hierarchy of court, right? What is the hierarchy of courts in India?
District, High, and Supreme Court.
So which one is highest court?
Supreme Court.
After that?
High Court and then District Court.
After that, district courts. Right. So we have a certain set hierarchy of courts. That means we have Supreme Court topmost. After that, high courts. These are superior courts. And below that, all the subordinate courts come. And that hierarchy is given in Constitution of India. And Constitution of India is considered as supreme law of land. It's like on top of everything. And if Constitution has said that Supreme Court is highest court, apex court, and below that all the 25 high courts are coming, then we need to respect that. And that is why whatever they are saying, that thing will be binding on the lower courts. All the subordinate courts, it will be binding. Okay. Now, this concept is called as that. Okay, judicial decision, you understood what is judicial decision. But now, in a judicial decision, there will be two different parts involved. Okay, when parties go before court and claim their rights, there will be two different parts in the judgment. Take, for example, there is a case wherein it's a case of child labor. Okay, a child is being employed as a worker in certain industry. So it's a case of child labor. The matter went before court. Now, when court will give decision, right, there may be two different parts involved in the judgment. First one being reasoned decision or ratio decidendi. Okay, what is reasoned decision now? Just because someone is appointed as a judge does not mean he can do whatever he likes. Okay, the person cannot be like, okay, what is the matter? Oh, child labor, this is the punishment, take it. That will not happen. Even though someone is a judge, that person needs to hear both the sides and properly give a decision. When a decision is being given, some fine, penalty, imprisonment, whatever is the punishment, judge needs to justify his punishment also. Okay, whatever is the punishment or compensation, whatever he has said, right, he need to justify it also. Judge would say that, okay, like child labor is a very serious crime. We have this law, that law talking about it, and these are the punishments. So in this certain case, these are the laws applicable, and based on this, that, so and so decision, this decision, that decision, we have decided to give this punishment to the person. That means it's not just simply he has said that this is the punishment, take it and go. No, he will justify the decision also. That means reason of decision, why that certain decision is given. For that, judge will mention a reason, and that is nothing but ratio decidendi. Okay, that's the first part of the judgment. And this is the most important part. When we say precedent, we mostly refer to this part only, which is binding. If next time similar situation comes before a lower court, they will refer this decision. That in so and so case, High Court had said like this, or Supreme Court had said like this, so we are going to follow it. That is nothing but ratio decidendi. And that's why it's so important to be updated with landmark decisions. Because whatever courts are saying, that is becoming like a precedent. Other courts will have to follow it. Okay, that's the first part. Is it clear?
Yes, ma'am. Ma'am, I have one question. Like, is it same for all type of courts? Like district court judge can also, I mean, like judicial decision in district court is also same as like this process.
We are coming to that also. Okay?
Okay.
We have that part. What is binding on whom? We'll come to that also. So first part we have is reasoned decision. You need to give a reason. You need to justify why you are giving that decision. Secondly, there may be some general observations which are made by judges. That means while deciding on that case, while hearing the stories and everything, judge may put some comments, right? Like even if your friend is telling you a story, you would always comment, right? Oh, this is very bad. This should not happen. And you know why this is happening? It's because of that reason. That means you are giving your opinions there, even though your friend was telling you a story. So like that, even judges may put their observations forward, right? When they are deciding a case on child labor, they may say that child labor is increasing too much, maybe because this free and compulsory primary education which is being given, maybe that's not enough. Maybe we need to provide this also, that also. Like that they can say. Those are not laws as such, but those are observations made by judges. As such, like a precedent, it's not binding, but yes, it's not like these observations are completely useless. They also have some importance. Like if legislation wants to make a law, they can refer to these observations that in so and so case, judges said that this law on free and compulsory primary education is not sufficient. So maybe we should make some changes. We need to bring some amendments. That means this observations made by judges has helped in a way the legislature to realize what all changes they need to bring in a given legislation. Okay, so it's not as such directly binding or something, but it may have some value still. And this part is called as obiter dicta. But when we talk about precedent, we basically refer to this part, ratio decidendi. And these two words or this division, right? You need to remember it anyhow. It's very important. Okay, this part is clear, right?
Yes, ma'am. Observation can be like can it be general observation, or like always it is legal observation?
No, not always legal observation. Sometimes it can be general observation also. That, just an example, okay? Court may say that why is child labor increasing? Because even though government has provided free and compulsory education, might be parents or guardians are not willing or ready to send their kids to school. Because if they are not going to school, they can do some labor, earn few rupees. Maybe parents are only not interested to send their kids. So that observation would also have value, and maybe the parliament can feel like maybe we need to impose it as an obligation, as a fundamental duty on parents, that whoever, like if a child is under your custody, you need to send that kid to for this free and compulsory primary education. That means it was a general observation, not as such a legal observation that this law is having that fault or something. They just said that might be parents are only not interested to send their kids to school. But that simple observation also can have some impact. Okay, it's not necessary that it has to be relating to a law only. It can be as simple as like a random observation also.
And ma'am, like observation can be different, like can be differ by courts. Like if Punjab and Haryana High Court observe something else than other court.
Yeah, it can differ, and that's why we are saying it's not binding as such, but it may be referred. Like if you are doing some research on a given topic, you may refer that in so and so case also this so and so judge made this observation. It's just an observation made. Okay, it, like we say, right, when you are watching news or a certain type of TV show, it has an impact on your mind. You also start thinking that way, behaving that way. So it's that way. Okay, when you are hearing the same observation again and again, you also start realizing that, oh, okay, might be problem is with parents or guardian only, that they are not sending the kids. Okay, it's fine, even though someone may have like a completely different opinion. That is also completely fine. They may say that might be schools are only not good, so kids are also not willing to go. That's completely fine, because it's anyways not binding, right? So there can be as many number of observations as there can be. It's completely fine there. Okay, but when we talk about ratio decidency, like the supreme one will be binding, okay, which is having like more evidentiary value, like more importance. We will discuss which one binding, but still, okay, for precedent, this is important, ratio decidency.
Okay.
Now you understood what is ratio decidency, what is obiter dicta. It's like say by the way, like we say, right, okay, this is the situation, oh by the way, this also happened. So by the way is just by side of it, it's there, it's not that important, right? If you are talking something that okay fine, exams would be this time, that time, exams are going to start from November 1st week, this that, and you're saying, oh by the way, exams will be offline. That means it does not matter whether it's offline, online, you anyways need to study, but it's just a something that you said on the side of it. Similarly, obiter dicta is not that important also, but it's just on the side of it, judges made an observation. Ratio decidency is the reason of decision. Definitely it's very important. Now, what is binding on whom? Supreme Court, it's apex court, highest court. Whatever Supreme Court has said, that will be binding on all courts in India. Okay, because it's Supreme Court. But what about high courts? Because Supreme Court, we just have one court. That's fine, we can follow it. But what about high courts? We have 25 different high courts. And like you said, Punjab and Haryana High Court may have a opinion or have a certain like a decision given. Karnataka High Court may give a completely different decision. Which one do we follow? Any idea what will happen in case there are 25 high courts giving 25 different types of judgment on one same issue? And Supreme Court is silent on that matter. Supreme Court has not yet said anything. So which high courts think who will follow?
I think Supreme Court is.
No, Supreme Court is silent on the matter. Supreme Court has not yet said anything because that sort of matter has not yet reached the Supreme Court. But all 25 high courts have said different things. Which one do you follow there?
I don't know. I don't like. I think there is some like. I don't remember the word. Like called jury, which is made by the Supreme Court. Like some bench of people who can decide this.
Is jury there in India?
I don't know. I don't think so. Nahi. No.
You search if jury is there. Like it's not there in India, but which country jury's opinion matter, or in which country jury is there? You search on that. Okay. But in India, we don't have jury. Judges would decide it. And if Supreme Court is silent on a certain matter, if Supreme Court has said, fine, it will be binding. But if Supreme Court is silent and 25 high courts have given different opinions or different judgment, then what will happen, you know? One high court, right? One high court, under that all its subordinate courts would be there. Like if you take the example of Punjab and Haryana High Court, okay? Under that Punjab and Haryana High Court, all the lower courts that are there in Punjab, Haryana, Chandigarh, all those lower courts would come. That means whatever Punjab and Haryana High Court has said, all the other lower courts in Punjab, Haryana, and Chandigarh will have to follow that thing only. Even though a certain judge or a magistrate might not completely agree to this viewpoint. Okay, that judge may feel that no, this is like completely nonsense. This should not happen. It is not giving justice to any parties, but still they will have to follow it. That person from his heart might be he agrees with another decision given by maybe High Court of maybe Madras High Court. But even then, even though personally he agrees to the viewpoint of Madras High Court, he need to follow this one given by Punjab and Haryana. Why? Because this lower court or subordinate court is coming under Punjab and Haryana High Court. Okay, so whatever Punjab and Haryana High Court has said, all its lower courts will follow that. Whatever Bombay High Court said, all its lower courts would follow that. Same goes for all the 25 high courts. Okay, is it clear?
Yeah, but ma'am, like for example, in the case of live-in relationship, like in like according to Punjab and Haryana High Court, it is still illegal. But according to like Supreme Court or like you can say other courts, it is legal. Like it comes under Article 21. So like in this case, I think, yeah, same situation. Yeah, okay.
Yeah, so and also sometimes what may happen, right? Maybe like I said, like 25 different high courts have given 25 different opinions, but might be there are two high courts, okay, where like 24 high courts gave different opinions. There is just one high court remaining. Okay, might be High Court of Karnataka was silent until now. Karnataka High Court was silent on that matter, and now is the time when a case has come before them. Okay, so now they are free. They can either give like a completely different their own decision, or if they agree with any of those remaining 25 high courts decisions, they can follow that also. Okay, so it is having persuasive value. It's not as such binding on them, but if they liked judgment given by any of those 24 high courts, they can follow it also. All right, so whatever decision is given by Supreme Court, you can observe it like this, you know, like might be Supreme Court is your college teacher. Whatever your teacher is saying, you need to follow it because you know she is having authority, right? If your college teacher says that from module 3 only precedent is important, definitely you would give importance to her statement, right? Because she is having some idea. Might be she will be the one who will set your question paper. So if she is saying that read precedent, one question will be there from precedent. That means you will, no matter what, follow her statement, right? You will somehow try to read it. But if same thing is told by one of your friends, that I feel precedent is important, from their question might come. In that case, your friend is at the equal level with you, right? Your friend is not superior than you. That means your friend and you are like two different high courts. There it depends. If you agree with your friend, you can read precedent. But if you feel that no, precedent is not that common topic, from precedent questions will not come, there you can simply ignore your friend also, right? So you and your friend are like two high courts. You can choose to follow the advice of your friend or not, but your teacher is like the Supreme Court. You need to follow that advice only. Okay, is it clear what is binding on whom?
Yes.
Okay, but then I said that Supreme Court's decision is binding on everyone. What about Supreme Court? Is it binding on Supreme Court? Supreme Court's decision?
Yeah, yes.
So is it like once Supreme Court said something, we cannot alter it?
No, like Supreme Court is binding by the Constitution.
Constitution to everyone is binding.
Yeah. So I think we can alter it, like any decision made by the Supreme Court.
But then what about precedent?
I'm confused.
So for Supreme Court's decisions, right, whether Supreme Court is bound by its own decision or not, there we need to consider. Are you aware there is a term called bench of Supreme Court?
Yes, ma'am.
You are aware. So what is a bench of Supreme Court?
I think like I heard in some movie, or like not that much of clear, but like it's similar. I don't have any idea. Like,
but you heard the word that there is something called bench of Supreme Court.
Yeah, yes, ma'am.
So bench of Supreme Court is what? Like what happens in a classroom? What happens? There are benches, right? There will be many different benches, and in one bench there will be few students sitting, right? And it happens, right, that we always sit with our friends only. That means there is this one bench where you will sit with might be two friends of yours. You are three people. Another bench where there is a bigger group, 5 people are sitting. In the same way, in Supreme Court also, when we say bench, that means how many people were there taking a decision on the matter. Okay, so bench of Supreme Court basically refers how many judges were present there deciding on a case. And when you are reading different cases, right, there also you will see 2 judges bench decided on this matter. Name of judges also will be written. 5 judges bench, 9 judges bench, then 11 judges bench, 13 judges bench, like that it will be mentioned. Okay, and by far largest number of judges were 13 judges bench, and it was case Mananda Bharati case. That was like the by far largest ever bench of Supreme Court. Okay, that many judges set together to decide on one matter. All right, so bench of Supreme Court basically means how many judges were there to decide on that issue. If there is just one person taking a decision, that means only one brain working there. If there are 5 judges, that means 5 brains working together. 13 judges, 13 brains working together, right? So that means decisions given by a higher number of judges, right? Like a higher bench will be binding on lower number of judges. Okay, and if you want to alter something which is decided by a 5 judges bench, it cannot be altered by a bench lesser than 5. It can be 7 judges, 9 judges, 11, 13, like that. Okay, so whatever decision is given by Supreme Court, it will be binding on a bench lower than that. If someone wants to alter it, it has to be by a higher number of judges that they can alter. Is it clear?
Yes, ma'am. Ma'am, then like what's the purpose of Chief Justice? Like what he can do?
Purpose of Chief Justice, again, he would usually take, for example, a important matter has come, court was deciding on it, but then later court felt that might be this is like a very important matter, we need to appoint many, like recently only last year what Supreme Court realized, right, that because of this COVID situation, like just because COVID situation is taking place, everything is shut down, nationwide wide lockdown and everything, but that does not mean crimes are going to stop. Crimes will be there, people want to uh, approach the court to get justice. So Supreme Court realized that maybe we need to accept this technological developments, we need to start hearing people through video conferencing. So Supreme Court decided to take up that matter to pass certain guidelines that how we can initiate that process of online hearing, online filing of cases and stuff. Okay, so there what happened, right? Only Chief Justice this Bobde, right? He was there and one justice was there. They both started with it. Later on, they felt that no, might be it is an important matter. So Chief Justice decided that let's add one more justice. Later on, they thought, no, let's add two more justices. So Chief Justice of India would decide how many judges are there, that many judges that person can assign. Chief Justice of India would also send recommendations regarding new appointments that are to be done. For that, he would be sending this from collegium, right? He would be sending recommendations and all. He is having a lot more functions. If the central government president is asking for some advice, he can give that. If he feels there is some important issue going on, he can take up that matter. He is having lot many different purposes, or for some cases he would also say Chief Justice was also part of one certain bench and he also gave a decision. Okay, so he is also like part of that only, he is also like a justice, but then he's Chief Justice. Okay, he is having few more additional powers, functions or authority as compared to other justices.
Like he cannot, like he alone cannot alter any judgment or like any law.
No, if it is given by a larger number of this, he cannot do. But if he single-handedly was deciding on a matter, he can say something on it. That is completely okay. Like if Supreme Court has not yet given any decision on a certain matter, in that case, he can do it. But not like something given by 13 judges bench, he cannot simply alter just because he is a Chief Justice. That would not happen.
Ma'am, just one more question, like who appoint this like bench of judges? There will be like 3 bench of judges or 4 bench of judges. Who will
It's
appoint?
not
Like,
like
who will make the
permanent.
decision?
Yeah, it's not like permanent that these many judges, these 3 people would sit always together. It's not like that. Case to case basis, they would decide. Okay, like the one I told last year, they took up the matter to decide on online hearing of cases and everything. There, Chief Justice can feel that, okay, might be this is an important matter. Let's add one more justice. So whoever is free, they can simply add that person also. It's not like hard and fast rule that these 3 people would be together, these 2 would be together. No, like friendship sort of thing over there. They can decide on it. Whoever is free like that, they can assign this also. Okay, but then matters are being decided. Like we have one specific statute also which says these all matters, single judges bench also can decide. These matters, it has to go to this bench, it has to go to that bench, it has to go to bench containing more than 5 judges. Like that, we have matters segregated, but as such, which one would go to whom, who all will sit together, no such hard and fast restriction over there.
Okay.
Another thing that we have is kinds of precedent. So kinds of precedents. Now, depending on who is giving, how it is being given, what is the precedent saying, we can divide it. Okay, first one being original and declaratory precedent. And these are like very much understood from the word itself. Okay, when we say original precedent, that means it's like original, newly it has taken place. So original precedent is where judges create a new law and the same becomes binding. Like for a certain given matter, no law was already existing, and for the first time, court has established it. In that case, we would say it's an original precedent. Like we were not having any law legislation as such talking specifically about witness protection. So Supreme Court introduced this concept of Witness Protection Scheme 2018, which is a detailed scheme talking about the rights and protections given to witnesses. So that becomes an original precedent. For the first time, Supreme Court said these are the things which should be given to witnesses to ensure their safety, because they are taking the risk and trying to help court in coming to a proper conclusion, right? So we need to provide these privileges to the witnesses. It becomes original precedent. For the first time, Supreme Court asserted that yes, these are the benefits which should be given to witnesses. Is it clear? Original precedent?
Yes, ma'am.
Next one is declaratory precedent. What is declaration?
Declaration is like some announcement.
Announcement sort of thing, right? That I declare this. Okay, like in certain affidavits and all also we say, right? I declare that I'm a citizen of India, I'm this, I'm that, all of that. So declaration is like I'm saying something. Okay, so declaratory precedent is where a known or established law is applied to a particular fact or case. Like already there is a law, already provision is there, it's written, it's already there. But then you are again asserting it, you are again declaring it. Okay, so take for example, there is Article 21 of Constitution. What is Article 21 of Constitution?
Right to life.
Right to life. So that means Article 21 is already there in Constitution. It's already written. You have right to life and personal liberty. Right? No person should be deprived of his right to life and personal liberty except according to procedure established by law. It's already there. It's already written. But what is life? What is liberty? That thing Supreme Court has asserted a lot many times. Supreme Court declared that even though under Constitution it simply says life and personal liberty, it also means privacy. It also means right to travel abroad. It also means right to clean air, right to education, right to livelihood. So many different things. That means provision was already there, law was already there. It's not like something they have invented or something, but they declared that these all things would also fall under it. This meaning is not just limited to this, it would extend to this much. That is nothing but declaratory. It was already there, it's declared again, it's properly established again by court. Is it clear? Okay. Original and declaratory?
Yes, ma'am.
So persuasive and authoritative and persuasive, this already we have mentioned, but I'll still tell you one more time. Authoritative precedent. What is having authority? It's like you cannot disrespect it, right? You need to follow it because it's having authority. Like I said, your college teacher is having authority. Whatever she says, you need to follow it. If she is saying precedent is important, you will have to read it, because there is almost 99% possibility that from there question is going to come. Why? Because of her authority. Similarly, authoritative precedent is something that must be followed by judges, whether they approve it or not. Like I said, Punjab and Haryana High Court has given a decision. A judge from the lower court, from the subordinate court, he is completely against that decision. But that judge believes, truly believes or accepts the decision given by maybe Karnataka High Court. But this judge cannot disrespect this authoritative precedent. He will have to follow whatever Punjab and Haryana High Court has said. So that decision becomes authoritative. Okay, so judge of High Court or any other court in India will have to follow decisions of Supreme Court. Similarly, whatever Supreme Court has said, we need to follow it. We don't have any other option. Okay, that is nothing but authoritative precedent. Is it clear?
Yes, ma'am.
In authoritative precedent, again, we have two classifications: absolute authoritative precedent and conditional authoritative precedent. What is absolute authoritative precedent? That means it's like absolute. You don't have any other option. right? Absolute authoritative precedents must be followed without any question. It does not matter how incorrect or like how much you are not satisfied or how much you disagree with it, does not matter. You need to follow it anyways. Like decisions given by Supreme Court must be obeyed by all the other courts in India, does not matter how much you are against that decision. That is nothing but absolute authoritative precedent where you don't have any other option but to observe it. Is that clear?
Yeah, yes, ma'am.
Next one is conditional authoritative precedent. That means, yes, it is authoritative, it is having authority, but then there is a condition. In some cases, it will have authority. In some situations, it might not have. Like the example which I told you, that decisions, authoritative precedents are binding. The court can disregard them under certain circumstances. Like Supreme Court is also bound by its own decision, but it can be altered, right? It is not binding on a bench which is like higher number of judges are there. Okay, if a decision was given by a bench of 3 judges, it will not be binding on a constitution bench where there are 5 or more than 5 judges. That is nothing but conditional authoritative precedent. That otherwise decisions of Supreme Courts are authoritative precedent. They are binding. But whether Supreme Court is bound or not, there it becomes conditional authoritative precedent. We need to look at number of judges sitting over there. After that only we can say whether it's binding or not. That is conditional authoritative precedent. Is it clear?
Yes, yes, ma'am.
Authoritative as in it's binding completely, but then it may be absolute authoritative precedent where we don't have any other option, but we need to agree. In conditional precedent, authoritative precedent, we can see number of judges. After that, we can clearly tell if it's binding or not binding. Last one is persuasive precedent, which means courts are not bound to follow, but it depends. Like I said, if your friend comes and tells you precedent is very important, it depends. If you feel that, okay, might be this friend is having some knowledge on previous year question papers, might be whatever he is saying is true. There it depends on you. If you feel like, you can believe. If you don't feel like, you can simply ignore his statement. That is nothing but persuasive precedent where court is free to take a call. If they agree, they can follow. If they don't agree, they can simply ignore it. Like decision of one high court will be persuasive precedent for another high court. But decision of one high court will be authoritative precedent for whom?
Sorry?
Decisions of a high court, on whom it will be authoritative precedent.
I think district court.
Yeah, right. All its subordinate courts, it will be authoritative precedent, but it will be persuasive precedent on other
Right.
Yeah. So this is basically the classification that we saw. Kinds of precedent. There is original precedent, declaratory precedent, authoritative precedent, persuasive precedent. Authoritative is further classified into absolute authoritative precedent, conditional authoritative precedent. Is this clear?
Yes, yes, ma'am.
So what is original precedent?
Like which is bound, like which is given by the Supreme Court, or like which is bound by the Supreme Court.
Which is like, is it original precedent?
So, like, sorry, can you please repeat?
Okay, fine. Let's start from first. What is precedent?
I think previously made judgments.
So binding nature that we need to follow it. Okay.
Follow.
Fine. What is original precedent?
I think that like the precedents which are like originally made mm, by the made by some court.
Okay. What is originally?
Sorry, ma'am.
What is originally then? Like, can there be like a duplicate precedent? What is originally?
Original is, ma'am, how can I like tell the meaning?
You can give an example. Fine.
Mm, uh, like uh, like provisions on GST is original.
Is it precedent? But
No.
then yeah, so you're close, right? That original precedent means something which was not previously decided, for the first time court asserted it. Might be we were not having a legislation on that. For the first time court decided that we need this thing, right? Court issued some guidelines or something. Like I gave the example of witness protection scheme, where for the first time court said we need to have something like a witness protection scheme. So for the first time court has said something. Maybe previously we were not having any legislation on that matter also. What is declaratory precedent?
Like where there is a like where there is only application of an already existing rule, um, an ma'am, like can I tell you tomorrow, like I have like too many questions, first I need to read them, like I need to
Fine. Yes, I agree. Okay, but I think you understood it, that declaratory is something which is already there. They are just declaring it one more time. Authoritative as in it is having complete authority, fully binding. Persuasive as in it depends on the judges whether they want to follow or not.
Yes.
Yeah. And for authoritative, we have two more classifications: absolute authoritative precedent, which is completely binding only, no other option, like Supreme Court's decision on all the other courts. It is absolute authoritative precedent. Conditional authoritative precedent as in there is a condition. Supreme Court is bound by its own decision or not, there is a condition. How many judges gave that decision, and at present, how many judges are there to decide on the matter? Based on that, we can say it.
Yeah.
Fine, then you can read this part. Okay, and yeah, so tomorrow we will discuss one more topic from the syllabus.